Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith-Rogers. It's been widely noted that pulse oximeters, devices used to read blood oxygen levels in hospitals and at home, are far less reliable for people of color and especially darker-skinned patients than for white patients. The error results in readings that are falsely normal, creating the potential for clinical staff to miss life-threatening complications. On Monday, July 8th, we're launching a special 3-episode series. That's all 3 episodes available at once, exploring the issue of racial bias in pulse oximeters. We'll look at why this long-standing problem only caught the nation's attention in recent years, despite the fact that there were known issues that were largely ignored by manufacturers and regulators. We'll also dive into the history that led us to the flawed devices that are used in hospitals everywhere and available for consumers on the market today. Finally, we'll hear from advocates from across the medical spectrum, including patients, clinicians, students, and scholars, about where we go from here to demand equity and ensure that it's built into the future of medicine. Look for this special series on Monday, July 8th, wherever you get your podcasts, or go to publichealth.jhu.edu/podcast. Today, making sense of the Supreme Court's recent rulings of abortion. Professor Joanne Rosen of the Johns Hopkins Bloomberg School of Public Health returns to the podcast to talk with Dr. Josh Sharfstein about a decision on access to the abortion medication Mifepristone and a decision about access to abortion during medical emergencies. She explains why both of these decisions were far from final and remain in a holding pattern. Let's listen.
Joanne Rosen, it's good to see you again. Thanks so much for coming to help us make sense of these Supreme Court decisions related to abortion.
You're welcome. Happy to be here.
Let's start with any opening remarks you want to make. I mean, as we were heading towards these decisions, there was a lot of attention to whether they would signal the next critical phase of legal actions about abortion access. What's the big picture?
The big picture is that in both of these really consequential post-Dobbs abortion decisions, the main issues at the heart of both were not addressed. They will both likely come back to the court at some later point, but for the moment, more or less the status quo is in place. Mifepristone remains on the market. The FDA's regulatory decisions have not been affected. And the HHS, Health and Human Services guidance around obligations to provide stabilizing care for pregnant persons is also in a holding pattern for the moment. So not final decisions, but a holding pattern.
Well, let's take these one at a time. Thanks for that great overview. You mentioned the Mifepristone decision. So to refresh everyone's memory, this all started with a case where a federal judge was ready to take Mifepristone off the market entirely.
That's correct. Back in April of 2023, this federal judge, Matthew Kaczmarek, who sits in Amarillo, Texas, and the case was filed in his district quite strategically because he's the only judge who sits in that district, and he has a well-known history of being very oppositional to abortion. He instituted a preliminary injunction early on that would have had the effect of taking Mifepristone off the market nationwide. That preliminary decision was pretty swiftly stayed by the Supreme Court for the duration of all of the litigation. And the Mifepristone case made its way to the Supreme Court, and that's the decision that came out on June 13th. And the decision itself focused on a threshold question of whether the coalition of plaintiffs who initiated this case actually had the necessary legal standing to bring this challenge in federal court in the first place. And the Supreme Court decided firmly and unanimously, they spoke in one voice, that this coalition of plaintiffs failed to meet the basic constitutional and legal requirements for standing. I can unpack that if you'd like, but that is what happened on June 13th.
So this was about who's allowed into the courtroom, not so much what the decision might be.
Precisely. In order to have standing to bring a case in federal court, it requires more than just being generally aggrieved or upset about some decision of a government agency or the government itself. You have to establish that you have suffered an injury that's concrete and particularized, not hypothetical, not abstract, that injury was caused by that government agency or the defendant, and that the court can address it with a remedy. And here, the coalition of plaintiffs were anti-abortion physicians and an anti-abortion medical association. None of them prescribe mifepristone or perform abortions. None of them have been required by FDA action to do so. And they had alleged that in a rather indirect and downstream way, they could, in fact, be required to provide abortion-related care if some person who had taken mifepristone suffered an extraordinarily rare, serious side effect or complication, turned up in their emergency room, and they were then required to provide care which would violate their consciences. And the court found clearly and unequivocally that this kind of abstract hypothetical argument was simply not sufficient to give them standing or to prove harm, and also that there was no causal connection between what they were alleging and the FDA's decisions with respect to mifepristone. So for these particular plaintiffs, the case was dismissed for want of standing, and the Supreme Court never got to the sort of merits issues around whether the FDA had acted appropriately and within the scope of its authority in its regulatory decisions around mifepristone.
Do you think those questions might be coming back to the Supreme Court with a different set of people involved in the case?
That is a great question. And I think it is, while not certain, I think it is very likely that this case or this issue about the FDA's regulation of mifepristone may be back before the court with different plaintiffs. And in fact, a few months ago, Judge Kaczmarek received a request for intervention in this case by the states of Idaho, Kansas, and Missouri. Those states all alleged that they have been harmed by the FDA's regulation of mifepristone, and Kaczmarek granted them permission to intervene as parties in this litigation. And these three states have argued that they have standing on a slightly different theory. So this case remains alive in Judge Kaczmarek's courtroom with three other potential parties. And so this case could move back through the court chain with Idaho, Kansas, and Missouri as plaintiffs, or there could be other plaintiffs who assert that they have a kind of standing that should be recognized. And in fact, one of the things that the Supreme Court didn't do in dismissing this case, they didn't have to do this because they dealt with the threshold issue of standing, but they didn't comment at all about the demonstrable and unequivocal evidence of the safety of mifepristone or anything about the appropriateness of the FDA's regulatory decisions in this regard. So they didn't send a signal out that might have acted to deter or dissuade potential future plaintiffs.
Interesting. That maybe was the price of getting 9 justices to sign on to the...
You are thinking like a lawyer in this. And yes, I think that may have been the price of getting 9 to sign on and the collective desire of the Supreme Court to be able to speak with one voice and say, we are united in dismissing this case.
So let's turn to the second case. This is a case about access to abortion services in a medical emergency.
Yes, correct. The second case, Moyle versus the United States, involves obligations under EMTALA, or the Emergency Medical Treatment and Labor Act. As you and I have discussed before, EMTALA is a federal statute that was enacted almost 30 years ago by Congress. And its purpose was to ensure that hospitals that receive Medicare funding must provide stabilizing treatment to any patient who comes into the emergency room with an emergency medical condition, regardless of whether they have insurance or are able to pay. And the Department of Health and Human Services released guidance reminding hospitals of their EMTALA obligations back in July of 2022 and said, if a pregnant person comes to your emergency room and they are suffering from an emergency medical condition for which abortion may be the required stabilizing treatment, then EMTALA obliges that you provide that treatment, even if there is a state abortion ban that might prohibit treatment in that circumstance. So where there's a conflict between providing stabilizing medical treatment under EMTALA and an abortion ban that allows abortion only in narrower circumstances, EMTALA will preempt the state ban. Shortly after this guidance came out, the Department of Justice brought a lawsuit against Idaho because Idaho's abortion ban prohibits abortion except where it's necessary to prevent the death of a pregnant person. And EMTALA requires stabilizing medical care, including abortion, where it's necessary to protect a grave threat to the health of the pregnant person, not merely to prevent their death. The Department of Justice then sued Idaho in order to get a preliminary injunction that would allow the EMTALA obligations to prevail in the event that Idaho's abortion ban would not allow abortion where the continued pregnancy was a serious threat to the person's health.
Got it. So you've got a very strict state law and a federal standard, which the Department of Health and Human Services is saying should prevail. What did the Supreme Court do?
So the Supreme Court, I have to get into a little bit of the procedure here because that directly links to what the Supreme Court did. So we had the district court that said to the extent that there is a conflict, the EMTALA obligations prevail. And a pregnant person in this crisis who requires an abortion care to resolve the crisis is entitled to get it, even if Idaho wouldn't allow it. Idaho then appealed to the Ninth Circuit Court of Appeals, and ultimately the Ninth Circuit preserved that preliminary injunction and blocked the Idaho ban. Idaho then appealed to the Supreme Court, and the Supreme Court in January agreed to hear this case before the Ninth Circuit would have heard its appeal in the ordinary course. And they also, really importantly, blocked the preliminary injunction and allowed Idaho's ban to go into effect, notwithstanding the EMTALA obligations. So when the Supreme Court ruled last week on June 27th, there were 6 justices that agreed to allow the preliminary injunction at the district court to go back into effect and block the Idaho ban where it conflicted with EMTALA. And in a 5-4 opinion, the justices dismissed this case as improvidently granted, a dig, a D-I-G, which is a Supreme Court term of art. What they said is, we should not have agreed to hear the merits of this case prior to the Ninth Circuit holding its appeal and ruling. They had essentially leapfrogged. So now they've sent it back to the Ninth Circuit to hear the arguments that Idaho raised, and they did not address the merits of the case, the argument about whether EMTALA can preempt the state abortion ban where it conflicts.
So for now, someone who comes to the emergency room and needs an abortion to prevent a severe health consequence can get one under federal law.
In Idaho.
In Idaho, that's what I mean, right? Yeah, in Idaho. But this case is still out there. And when the Supreme Court finally rules, we don't know what that will happen to that person anymore.
Yes, precisely. So the Mifepristone case may well come back to the Supreme Court, either by one of those states that was granted party status or by some other plaintiffs who established standing. The EMTALA case will definitely come back to the Supreme Court in one of 2 ways, and possibly both. Either the Ninth Circuit opinion, however the Ninth Circuit rules, about whether EMTALA prevails or the Idaho ban prevails, one of the parties will appeal to the Supreme Court. As well, Texas immediately sued the Department of Justice with respect to the EMTALA guidance back in 2022. And the Fifth Circuit Court of Appeals in Texas ruled in favor of Texas and said that Texas's strict abortion bans prevail over the EMTALA obligations. And that's why in the state of Texas, pregnant people in acute medical crises have had to leave Texas to get abortions where abortion is required to stabilize their health. And the Department of Justice filed a petition for review of that Fifth Circuit opinion. It's in front of the Supreme Court. The Supreme Court has not yet decided whether to hear the Department of Justice's appeal of the Texas decision. But that case continues to be in front of the court. So one way or the other, this conflict with respect to EMTALA obligations will be back in front of SCOTUS. And I do want to say that in January, when the Supreme Court stayed the Idaho District Court preliminary injunction, the court noted in its decision, or Justice Kagan did, that over that intervening period, there were 6 pregnant women who were in grave medical circumstances who had to be airlifted out of Idaho to other states in order to obtain the necessary stabilizing abortion that they needed. So we've kind of had proof of concept that where there is a conflict between the Idaho ban and EMTALA obligations, people may become so sick that they require emergency abortion care and cannot get it in Idaho. So this isn't sort of abstract, it's real.
So 2 cases that are still in a holding pattern, as you said, 2 cases that could come back to the Supreme Court, but no decisions to reduce access to abortion for right now. I'm going to ask you a somewhat cynical question, Professor Rosen, which is, with the election coming up, do you think that that might have affected the decisions to keep these cases in a holding pattern where judges may not want to restrict abortion access further before an election? Or do you think that's not a fair question to ask?
I think it's a fair question to ask, and there has been a lot of speculation about this. With respect to the Mifepristone case, the argument that the ruling that the Supreme Court made on standing, I think they would have made at any point in time because the court's jurisprudence on standing is really clear. And this wasn't a case on the margins. There was no standing. They may have had less appetite to deal with it before the election. They know that abortion is a controversial issue and it sort of arouses voters. The EMTALA case, it would be difficult not to see the outcome where they decided not to hear the issue that back in January they said they were going to hear, and they dismissed it as improvidently granted. It would be not a stretch to speculate that they wanted to take this off of its docket and save it for some point after the next election.
Well, Professor Joanne Rosen, thank you so much for joining me, as always, to make sense of the Supreme Court and its decisions on reproductive health. Thank you very much.
You're welcome, Josh.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, Stephanie Desmond, and Grace Fernandez-Ciceri. Audio production by J.B. Arbogast, Holly Cardinale, Spencer Greer, Matthew Martin, and Philip Porter, with support from Chip Hickey. Distribution by Nick Moran. Production management by Catherine Ricardo. Social media run by Grace Fernandez-Ciceri. Analytics by Eliza Rosen. If you have questions or ideas for us, please send us an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.